We'll start with the fresh complaint and then we'll go to the bond violation. On the record in state of Michigan versus Keith Richard Eskin. Appearance, please.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Eskin. My appearance is limited for this hearing only.
Thank you. And you, sir, are you Keith Richard Eskin?
Yes, ma'am.
Okay. What I have here is a felony complaint. This alleges that on or about June 23rd, 2023 at 1534 Bailey Street, City of Lansing, Ingham County, Michigan, count 1, home invasion, first degree, that you did break and enter or did enter without permission a dwelling located at 1534 Bailey Street. And while entering, president, or exiting the exiting, you committed discharge of a firearm, a felony. And while entering, president, or exiting the dwelling, Jody Gilbert was lawfully present therein. That is a felony punishable by 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2, discharge in or at a building that you did intentionally discharge a firearm at a facility that you knew or had reason to believe was a dwelling or potentially occupied structure, and or in a facility that you knew or had reason to believe was a dwelling or a potentially occupied structure in reckless disregard for the safety of another. Felony, 10 years and or $10,000 with mandatory forfeiture of the weapon or device. Count 3, that you did without just cause knowingly kill a dog. Felony, 4 years and or $5,000. A consecutive sentence may be imposed for any other conviction. Not more than 500 hours of community service. Court may order a psychiatric evaluation. Court may order cost of prosecution, care, housing, or veterinary care as applicable, and may be ordered not to own or possess an animal. Do you understand those 3 charges and the possible penalties?
Yes, Your Honor. I have a quick question, Ms. Buchanan.
Well, you can ask a question. I don't know if I'll answer it. Go ahead.
Okay, thank you. So I was just told by the officers that I was being charged with something totally different. And now I'm getting told I'm getting charged with discharge at a building.
Yep. So whatever I say is that's the whole purpose of arraignment. So you can officially hear the charges. So I have the official court document, and the charges I'm telling you are the official charges in this file.
Yes, Your Honor. Thank you.
Okay. So the 3 charges are home invasion, first degree, discharge in or at a building, and animal killing, 3rd degree. All right, Mr. Austin.
Thank you, Your Honor. Well, I can appreciate the seriousness of the allegations. In this case, they are allegations. At this point, the presumption is that Mr. Eskin did not commit them. What I can say, he appears to be a longtime member of the community. He has family ties, I know, including his mother. He also has a minor child. Mr. Eskin informs me that he's also working. And given that, Your Honor, I think bond in the amount, if the court is to set a cash surety bond, I would just ask that it be far less than what the people are requesting. I would ask that it not exceed $30,000. Thank you.
Is Mr. Eskin working at this time?
Yes, he informs me that he's working.
Okay. In addition to the bond recommendation, I do have a copy of Mr. Eskin's CCH, and it substantially is similar to that which is alleged by the prosecutor. Several sort of juvenile encounters, and then I believe there was a probationary term that was revoked. And I believe his special status was revoked along with that. Yeah, it was definitely revoked the end of 2021 for a gun charge. Looks like 2 counts, gun charges, revoked youthful offender status. Based on the fact that Mr. Eskin has prior gun charges, convictions, unsuccessfully completed a term of probation. Mr. Eskin, you of course must attend court dates. I've given you 2. Do not leave the state without permission of the court. Do not commit crimes. You must report to pretrial services on the first business day following your release. Do not use alcohol, marijuana, illegal controlled substances. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behavior. Do not assault, harass, intimidate, beat, molest, wound, or threaten Gavin Adams, Jody Gilbert, or Donovan's to death. You are not to have any contact with Gavin Adams, Jody Gilbert, Donovan to death. You're not to be within 2,000 feet of where they live, work, or go to school. If you violate an order of no contact, you can be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. This order is about you. It's not about them. So if they were texting you, if you text them back, you go to jail. If they're calling you, if you call them back, you go to jail. They do not have authority to give you permission to violate a court order because it's not their order. It is the court's order. So if they invited you to meet up with them and you went, you'd still be risking jail. You understand that?
Yes, Your Honor. I have one question though. Did you say 100,000 cash surety or 10%?
Correct. I said cash surety.
Okay, thank you. I just wanted to.
Now, we have one more order of business here, which is I've been given a bond violation, which I believe is that this event that is alleged to have occurred violated your bond at the 30th Circuit Court. I do not have in my hand the case number for that, but maybe Mr. Austin has it, or maybe I can look it up. It's just gonna take
Yes,
me-
Your Honor, it appears to be 23080 FH.
080FH.
Correct.
Okay, I hope I did that. 080. Okay. So in state of Michigan versus Keith Richard Eskin 23080FH, it is alleged, Mr. Eskin, that you are on a bond and that the bond prohibited you from committing any crime while released and from possessing a firearm. If you did violate your bond conditions, you will, your bond that you previously were on could be forfeited. You could also be in contempt of court, for which you could be sentenced to up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. For contempt of court, you do have the right to have an attorney, and I believe you already have an attorney on this offense. Is that right, Mr. Austin?
Yes, Your Honor, Mr. Goodrich represents him on that file.
Okay. You also have the right to have a trial, not by a jury, but just by a judge. But at that trial, it'd have to be proven that you violated a court order beyond a reasonable doubt. Since I do not have this file, it's not my file, you'll be remanded until you see a circuit judge regarding your bond violation.
I got $10,000 right now.
So, from my understanding, my bond will only be remanded until I go to court for my circuit court judge, right?
So on one file, you need $100,000 cash surety. And then on the other file, the circuit court judge will decide what to do about your bond violations. So that judge could reinstate your bond. That judge could establish a new bond. That judge could keep you in jail. I don't know what they'll do.
Okay, so I have to wait till my next court hearing for that day or something to see my judge for that charge?
I think what will happen is they'll set a court date fairly quickly, maybe in the next week or so, in order to see you about your bond violation. So you should see a circuit judge pretty quickly.
Okay, and can the circuit judge? Never mind. You're right. Okay, thank you.
All right, I think that's it for Mr. Eskin. Is that right, Mr. Austin?
I have nothing additional, Your Honor. Yes, thank
All
you.
right, thank you. Just want to make sure. Nicole Jones can be next.
Figure it out.
On the record in state of Michigan versus Nicole Marshawn Jones.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Ms. Jones for her arraignment only.
Thank you. Are you Nicole Marshawn Jones?
Yes.
Thank you. Today is the date of your arraignment. What I have here is a felony complaint. This alleges that on or about June 23rd, 2023 at 1421 East North Street in the city of Lansing, Ingham County, Michigan. Count 1 is assault with a dangerous weapon, that you did make an assault upon Dayton Jones with a dangerous weapon, a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. That is a felony punishable by up to 4 years in prison and or $2,000. DNA to be taken upon arrest. Count 2, felony firearm, that you did carry or have in your possession a firearm, a pistol, at the time you committed or attempted to commit a felony, that being the assault with a dangerous weapon. Felony 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3, that you did make an assault or assault and battery upon Dayton Jones, an individual with whom you've had a child in common or a resident or former resident of your household. That's known as domestic violence, misdemeanor, 93 days and or $500 in fines. Do you understand these 3 charges and the possible penalties?
I was the one attacked, and I was only.
No, that's not what I asked you. Okay, Ms. Jones, if you would like a chance to be out on bond, you need to listen to the question and understand the proceeding. This is an arraignment. We do not talk about the facts of your case. Do you understand the charges and the possible penalties?
Yeah.
You have the right to have an attorney in this matter. If you cannot afford one, we can see if a public defender will represent you. You have the right to a trial, that could be by jury. You have the right to remain silent. Anything you say orally or in writing will be used against you in court. You have the right to have an attorney present with you during any questioning by law enforcement. Do you understand these rights?
Yeah.
Would you like a public defender to assist you?
Yes.
Okay.
These are really what I have to be charged with. I should.
This is what you're accused of. That's why the next step is you'll have a preliminary examination. That's a hearing where the government.
Me.
Pardon?
Nothing is actually charged like on my record yet.
So you're charged. So your criminal history will show that there's an arrest and fingerprints were taken, but that's like a law enforcement record. That's a law enforcement record. And if you're found not guilty, you can get those fingerprint records destroyed. But as of today, you've been arrested and accused of 3 crimes.
Okay.
Okay. Now you have the right to have a preliminary examination. That's a hearing where the government must bring some evidence to demonstrate probable cause to believe that the felony charges occurred and probable cause to believe that you're the person who committed the felonies. You will have a probable cause conference before that day where your lawyer, yourself, and the prosecutor can make sure you have all the information and evidence you need to be ready for a preliminary exam. The probable cause conference will occur July 7 at 8:30 a.m. with Judge Ward. And then you'll have your preliminary exam July 14 at 9 a.m. That will be with Judge Ward as well. Now that first hearing, the probable cause conference, can be done by video conference like we're doing now if you like. Of course, you're always invited to come in person if you cannot video conference. The second date, because it's an evidence and testimony type hearing, you will need to be present here in person at the courthouse in order for that hearing to occur. You understand your obligation to come in person for that?
Mm-hmm.
Is that a yes?
Yes, I heard you.
Okay, thank you. Now, one of the conditions of your release is going to be to have no contact.
726, that would be my grandma's number.
Okay, that's the number I just asked you about.
Was it?
Yes.
I got
Yes, it
into car accidents 2 years ago, and I get concussions after getting my head busted. So excuse me, I really didn't hear you say that. But and the address for my stepdad will be 3260 North Waverly Road.
Well, if you're not going to be there, I'm not writing that address down.
Oh, I'll be there.
You just got done telling me that you're not going to go there.
Then I'm not going to be at his address. I mean, my stepdad. I mean, I'd be there or at my friend's that's literally stays right next to him. So his is 3260, hers is 3258. Those would be literally my 2 addresses. They live right next door. My best friend that brought me my keys last night, that took my car and my keys into possession with the
You-
police.
You need to
And
stop
then my
talking.
stepdad-
You need to stop talking. So you said 3260 North Waverly. Is there an apartment number or anything I need with that address?
North Waverly Road, Lansing, Michigan, 48906.
Okay. Are you on probation or parole, in any of
Been
your?
arrested? I've never had a juvenile record or anything. No.
Mr. Austin, I'm gonna read into the record the bond request from the prosecution. This says, prosecution says to note for protection of the public that this crime charge involves violence towards another person. Crime charge involves possession or use of a firearm, and it involves an intimate partner. The prosecutor is not making a specific money request, just stating that they want no contact orders for Dayton Jones and in order not to possess firearms.
Wasn't even mine.
Mr. Ms. Jones, you need to learn when I tell you not to not talk. If you keep it up, you're gonna end up finding yourself at a disadvantage. Mr. Austin, please proceed on bond.
Yes, thank you, Your Honor. Speaking with Ms. Jones, she purports to me to have no prior criminal history whatsoever. I know in our system, I did not see anything other than maybe some traffic misdemeanors. She is gainfully employed. She's working. She also has children that she supports. She has ties to the community, as well as family ties to the community as well, Your Honor. She has provided the court with an address where she can stay so that she can comply with the court's no contact order. The only thing I believe from speaking with Ms. Jones, Your Honor, she may have a child in common with the complaining witness in this case. And if that is the case, I would ask for some type of third-party contact. It's just a general variance on the overall no contact order. I understand the allegations involve violence, Your Honor, but the presumption is that Ms. Jones did not commit them. Given the factors that I have mentioned, Your Honor, I would ask the court to consider personal recognizance release or any alternative, a reasonable 10% bond. Thank you.
History shows no prior. A review of Ms. Jones' criminal history shows no prior arrests in the state of Michigan. However, I do have concerns about Ms. Jones' willingness to comply with court orders based on how this entire arraignment has occurred. Bond will be set at $2,500 personal recognizance, but there will be a tether requirement for release. I'll get to that in just a second here. Ms. Jones, a condition of your release includes attending court dates. I gave you 2. Do not leave the state without permission from the court. Do not commit crimes. You must report to pretrial services on the first business day after your release. You should receive a brochure there from the jail with a phone number that you need to call. And then they will generally, you'll have to leave a voicemail and they'll call you back. So make sure you leave a good number to be reached at and that you take their call when they do call you back. Do not use alcohol, marijuana, illegal controlled substances. Do not possess or purchase a firearm or dangerous weapon. Do not engage in harassing, intimidating, stalking, or threatening behaviors. Do not assault, harass, intimidate, beat, molest, wound, or threaten Dayton Jones and Kimberly Noel. You are not to have any contact with Dayton Jones and Kimberly Noel, no direct contact and no indirect contact, except you may have third-party contact with Dayton Jones regarding your minor child only. It's only third-party contact, not direct contact. It's only regarding a child. If that isn't your situation, then no contact at all. You're not to be within. You're not to be within 2,000 feet of Dayton Jones' home, work, or school. If you violate an order of no contact, you can be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines separate and apart from that which you already face. I will say, I have authorized, you can go to the residence one time to pick up your personal belongings in the presence of a police officer. It's the only way you can go there is if a police officer goes with you to grab your things. You should know this order is about you. It's not about these other people. So if they're texting you, do not text them back. If you text back, you could go to jail. They're calling you. If you call them back, you're the one who risks jail. They do not have authority to give you permission to violate a court order because it's the court's order, not their order. So even if they invited you to meet up with them and you went, you'd still be risking jail. You understand?
Okay,
Okay.
and then how do I do the bond and stuff? Like, what is that process?
So the bond is a personal recognizance bond, which means you don't have to post money to get out of jail, but you do need a tether. So they'll take you out to the county and they'll tell the tether company and they'll come over and talk to you about what you need in order to set up the tether.
Okay, okay.
All right.
Okay.
Okay. All right. Anything else on this case, Mr. Austin?
Nothing additional, Your Honor. Thank you.
Okay, you're all set, Ms. Jones. Files, we'll do the fresh one first. I guess fresh, it's a warrant. He's never been arraigned on, I guess is the way I would put it. All right. All right, on the record in State of Michigan versus Robert Harold Glasgow, 2001198SM.
Thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mr. Glasgow for the limited purpose of this hearing only.
And you, sir, are you Robert Harold Glasgow?
Yes, ma'am.
Thank you. In this case, what I have here is a misdemeanor complaint. This alleges that on or about January 1st of 2020 at 4312 Glen Burns, City of Lansing, Eaton County, Michigan, that you did cause physical harm to a child by repeatedly striking the child with a belt. That is an offense known as child abuse in the 4th degree, a misdemeanor punishable by up to 1 year in jail or probation of up to 5 years. Do you understand the charge and the possible penalty?
Yes, ma'am.
You have the right to have an attorney in this matter. If you cannot afford an attorney, we can see if the public defender will represent you. You have the right to have a trial that could be by jury. You have the right to see, hear, and question all of the witnesses against you at trial. You have the right to bring witnesses in your own defense, and you could get a subpoena to make them appear. You have the right to testify at your trial if you wanted to, but if you did not want to testify, the prosecutor could not use your silence against you. You have the right to be presumed innocent unless they can prove that you are guilty beyond a reasonable doubt. Do you understand these rights, Mr. Glasgow?
Yes, ma'am.
Are you requesting a public defender to assist you in this matter?
Yes, ma'am.
Okay. Are you on probation or parole in any court?
No, ma'am. I don't think so.
Well, that's something we got to talk about because the next arraignment is going to be absconding from probation. In the meantime, there is a person who you will be unable to have contact with during the time of this case, Mark Cruz. I have an address on Glenburn. Does Mark Cruz live at the Glenburn address with you?
No, not anymore, ma'am.
Okay. Do you still live at the Glenburn address? Is that the address I should be using for you?
Yes, ma'am.
Okay. The phone number they gave me that ends 8531, is that still a good number for you?
May I check in my pocket? I'm not good with numbers, so I wrote them down.
That's fine.
Okay. My wife's phone number.
It's the emergency.
Yeah, I lost the day.
517-554-6695.
Okay.
Okay. And we actually she has 2 phones, so if she doesn't answer that one, the other one is 517-619-4266.
Okay.
Speaking with Mr. Glasgow, sounds like this allegation is a few years old, so it sounds like he hasn't had police contact or any new charges in the interim.
It's a good idea, you'll appear on this file as well.
Yes, Your Honor.
All right. Mr. Glass. This is a little more difficult because, Mr. Glasgow, you've been gone a long time and your original judge wrote. Okay. Prince Alexander Wallace. All right, on the record in State of Michigan versus Prince Alexander Wallace.
And good afternoon, Your Honor. Jared Austin appearing on behalf of Mr. Wallace for today's arraignment only.
And you, sir, are you Prince Alexander Wallace?
Yes, ma'am. Good afternoon.
Thank you. Sir, today's the date for your arraignment. What I have here is a felony complaint. This alleges that on or about June 23rd, 2023 at 1026 North Pine, City of Lansing, Ingham County, Michigan, count 1 unlawful imprisonment, that you did knowingly restrain Cecilia Wallace to facilitate the commission of assault with intent to do great bodily harm less than murder or by strangulation, a felony. That is a felony punishable by 15 years in prison and or $20,000 in fines. There is a SOAR notice here as well that says that if there was a sexual component, I suppose, this is a tier 1 sex offender registration act if the victim is a minor. It's tier 2 offense if the defendant has a prior conviction for a tier 1 offense. It's a tier 3 offense if the defendant has a prior conviction for a tier 2 offense. Count 2, assault with intent to do great bodily harm less than murder or by strangulation, that you did make an assault upon Cecilia Wallace by strangulation or suffocation. Felony 10 years or $5,000 DNA to be taken upon arrest. Count 3, felony firearm, that you did have or carry in your possession a firearm, a pistol at the time you committed or attempted to commit the felony of unlawful imprisonment. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 4, felony firearm, that you did have in your possession a firearm, a pistol at the time you committed or attempted to commit assault with intent to do great bodily harm less than murder or by strangulation. Felony 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 5, domestic violence. You did make an assault or assault and battery upon Cecilia Wallace, an individual with whom you had a child in common, or your spouse. Normally, that's a misdemeanor punishable by 93 days in jail. But I do have a second offense notice that says, take notice, defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating statute on or about March 19th, 2015, and therefore upon conviction will be subjected to an enhanced sentence, misdemeanor 1 year and or $1,000. Do you understand these 5 charges and the possible penalties, sir?
Yes, Your Honor.
Are you on probation or parole in any court?
None.
I believe I had a bond request in this case. Let's see here, Mr. Austin. I do. It's this one says they're making a bond request for the protection of the public. The crime charged involves violence towards another person. The crime charged involves possession or use of a firearm and involves an intimate partner. There have been threats to kill the victim or family, recent separation or divorce, escalation of violence or risk-taking over time, acute depression or unpredictable and violent mood swings. Crime was committed in the presence of children. Defendant was intoxicated with a firearm on his person during his assaults on the victim, as well as during his highly escalated behavior toward police. Defendant made a statement along the lines of, he should have blew you away, blew the whole family away. The people request a GPS tether with victim exclusion zone and notification. And then, of course, no contact with Ms. Wallace, no firearms. Mr. Austin on the bond.
Yes, Your Honor. Thank you. Mr. Wallace informs me that he has lived in our community nearly his entire life. And as the court is aware, he is married He also has children. While he is currently unemployed, Mr. Wallace informs me that he is set to start working a new job next week. It sounds like it's been getting close to upwards of 10 years, at least since his last domestic assault conviction. Your Honor, I think there are bond conditions and safeguards that could be put in place to address any safety concerns. He does have a separate address so that he can abide by the no contact order. He also obviously has family ties to the community. I would ask the court to consider granting a reasonable 10% bond. Thank you.
So I see that Mr. Wallace's Michigan criminal history really only shows the one prior offense conviction that is the subject of a second offense notice. Anything else was actually dismissed or acquitted, so that's the only thing on there. However, it is not lost on me that it is assaulted, and this offense is alleged to be. Of course, you must attend your court dates, sir. I gave you 2. Do not leave the state without permission. Do not commit crimes. You must report to pretrial services on the first business day after your release. They should give you a brochure there at the jail with a phone number that you need to call them. And if you have to leave a voicemail, make sure you leave a good number and you take their calls. Do not use alcohol, marijuana, or illegal controlled substances, and you'll participate in a one-time monthly random ETG test to assure your sobriety, because this offense is alleged to have occurred with significant intoxication. Do not possess or purchase a firearm or dangerous weapon. Do not harass, intimidate, stalk, or threaten anyone. Specifically, do not assault, harass, intimidate, beat, molest, wound, or threaten Cecilia Wallace. Do not have any direct or indirect contact with Cecilia Wallace. You're not to be within 2,000 feet of where she lives, works, or goes to school. You may go to the residence one time in the presence of a law enforcement officer in order to obtain personal belongings. You must wear a GPS tether with victim notification if possible, with a exclusion zone around that 2,000 feet to assure that you're complying with the court's order. If you violate an order of no contact, sir, you could be arrested without a warrant. Your bond could be revoked. You could be in contempt of court, for which you face up to 93 days in jail and or $7,500 in fines, separate and apart from that which you already face. This order is about you. It's not about her. So if Cecilia is texting you and texting you, calling you and calling you, she is allowed to do that. You're the one under a court order. If you call her back, you risk going to jail. She does not have permission or authority to give you permission to violate a court order, because it's not her order, it's the court's order. So she invited you to go meet up with her and you went, you'd still be risking jail. You understand, sir?
Yes, ma'am.
Okay. Mr. Austin, anything else for Mr.
Could you give me that bond amount one more time?
7,000, 10%.
Okay, thank